My name is Savante Myrick. I am the president of People for the American Way. A real privilege because this organization, as a lot of you know, is 45 years, one of the premier civil rights and advocacy organizations in the country. And we were founded to stand up for a version of truth, justice, and the American way that relies on some bedrocks that go all the way back to our founding, that go back to 1776, when we decided that we were going to be a nation without a king, and that the way we would restrain the power of the executive and shape decision-making for the benefit of all of us was to split up those powers, to check and to balance it, of course, with a Congress and a court, to make sure that that court was impartial. And it hasn't been perfect, but really since the late 1700s until now, we have managed to overcome quite a few horrific challenges and hold our nation together and keep advancing the cause of human rights. Well, how's it going right now? How are those checks and those balances working right now? Well, Congress is supposed to check the executive. Are they doing it? No. Mike Johnson seems to have handed his gavel over completely and is just not doing its job. It is a rubber stamp for a lawless president. How about the courts? Well, good news here. I think most folks here know that circuit and district court judges, many of them who've been nominated by presidents of both parties, are stepping up and doing their jobs. So whether Trump is sending masked secret police, thugs to terrorize our communities, or the military, as we're here in Washington, D.C. today, marching up and down the street, arresting people just for exercising the First Amendment rights, some judges are saying no. But Trump's collaborators on the Supreme Court are not doing the same good work that those circuit and district court judges are doing. Those collaborators, Trump's collaborators, the same people said he could stay on the ballot even though he was constitutionally disqualified for having led an insurrection. These are the same Supreme Court justices who gave him immunity for illegal acts that he takes as president. And yeah, the same judges that overturned Roe v. Wade, raising the wall that separates church and state. And they think a person's right to carry a gun is more important than the lives of the people we all love. These justices, we know, were put on the court for a reason, and they're doing exactly what we expected. And this term we think will be difficult, but those people on the court are not the only people who have power. We have power. We have all the power. And this isn't the first time that the country's democratic norms have been challenged, not by a long shot. We've defeated fascism, both at home and in Europe. We defeated McCarthyism. Before that, Jim Crow. Will defeat Trump, MAGA, Christian nationalism. I really believe that. And so even though this is a tough briefing to get through, I think the reason you all clicked to join is not because you were looking for good, happy news, but you're looking for knowledge, because knowledge is power. One of the best ways to organize, to fight for our freedoms, is to make sure that we know what's going on so that we can then go to our neighbors, to our friends, maybe people we're not even particularly friendly with, and make the case for why this is important. So the more I know about this current Supreme Court majority, the madder I get. But I think it's a healthy anger. I don't know if my therapist agrees, but I think it's a healthy anger, because as long as we don't panic, or rather we panic constructively, we can still fight back. It will take time, but I believe that we can change this court. So we have a panel of experts today, expert attorneys, that I would like to introduce you to. I'll ask a few questions, and then we do have some time for Q&A from all of you members. And I do see even more members are joining. Alyssa Milano, a longtime board member, is also here. Thank you for joining us, Alyssa. And it would be only right that we actually start off with Lisa Graves. Lisa is a panelist here. If you don't know Lisa Graves, she is the founder and the executive director of True North Research, which is a It's an investigative watchdog group, national group. It works with journalists, researchers to shine a light on dark money, right? She's one of the foremost experts in how special interests distort public policy because she's worked, I mean, at the DOJ, it was under Janet Reno, John Ashcroft, in the Senate for Senator Leahy, for the Judiciary Committee, where she was often, would you say, bombarded by Elliot, Paul, and Marge? Uh, Collaborated with Elliot, Paul, and Marge, and our longstanding work at People for the American Way of trying to shape and inform those who appoint these judges so that we can get good, fair justices. Lisa has written a terrific new book called Without Precedent. It's how Chief Justice Roberts and his accomplices rewrote the Constitution and dismantled our rights. Now, Lisa, I want to ask you about this book because Without Precedent, there's this falsehood. This is 20 years on in the Roberts Court, and there's this falsehood that Roberts is a fair-minded institutionalist. He would blunt the worst instincts of the Republican nominees to the court, when in fact he's led this extreme rightward lurch. And instead of calling the balls and strikes, which he famously promised to during his confirmation, he's clearly a player in this game. So I want to ask you, he came to the court with an agenda. What should we know about that agenda? And what should we know about how he got here? Not just so we know, but what should we know about how we got here that could shine light on how we get ourselves out of the mess we're in with this court?
Well, Svante, thank you so much for that lovely introduction. And it's so wonderful to see you and Marge and Elliot and Paul, and to see that there's so many people zooming in from across the country who care about our laws, who care about justice, and who want to learn more in the face of the multifaceted constitutional crises that we're facing. So, yes, I wrote this book. It's just out now. I don't have it hold up, but imagine I'm holding up the book Without Precedent, because I wrote it as a real labor of love for the promises of our country that in many ways John Roberts was chosen to break. But let me just start a bit at the beginning, which is that when Roberts appeared before the American people, really for the first time that people were really focusing on him in 2005, he promised the American people that he would be a fair umpire, that he would only call balls and strikes. That analogy has been very sticky. It served him well. It was a very clever bit of advocacy by a Supreme Court advocate, but it wasn't true then, in my view, and it certainly has been proven to be false in the 20 years since he was confirmed. And he also promised the American people, and this made the headlines for the New York Times that week, he promised that no one was above the law. And when it mattered the most, when that issue came squarely before the United States Supreme Court in the case called Trump versus United States last year, the U.S. Supreme Court under John Roberts, rather than deferring to, not unmooring the decision of the panel of bipartisan appointed judges below, decided to not just rewrite the law in some general sense, but really to destroy a core principle in our Constitution, which is that principle that no one is above the law. And that ruling by John Roberts, that the New York Times in a later investigative report detailed how he orchestrated, how it was his vision, that ruling is a counter-constitutional ruling. It is counter to the express language in Article 2 of the Constitution, which provides not once but twice that a president has a duty, and that duty is to faithfully execute the law. That's the same oath that a president takes on Inauguration Day. What could be more faithless? What could be more unfaithful than breaking the law, and doing so, breaking not just civil laws, but breaking criminal laws, as Donald Trump was indicted for his actions fomenting the violent January 6th insurrection in 2021, and the activities around that, to deny the American people, to deny our vote, to block the counting of our votes that Donald Trump lost in that election and wanted to remain in power despite the will of the American people. That was Roberts' decision. Now, Roberts' decision, he wrote that decision. He, in doing so, really paved the way for Trump's return to power. Had Roberts and the Republican appointees to the court not intervened last summer, there would or could have been a trial last summer on these crimes. The American people would see for their own eyes the actual evidence, not some pundits' view, but the actual evidence that was being presented about the crimes that Donald Trump was accused of and what he did to facilitate them. Instead, some of the American people were sent a message by John Roberts that Donald Trump did no wrong and could do no wrong, which fed and fueled his narrative that this was some sort of political prosecution, when in fact it was a series of criminal investigations that were well justified by the law, and unfortunately came late in the administration, pushing it so close, in the spring and summer of 2024. But the fact is that the Roberts Court was asked previously in 2023 to dispense with this really outlandish notion that a president is above the law, that a president is immune from prosecution, because the Constitution expressly does not provide any such immunity. And as you all, I'm sure, recall, during the second impeachment trial after Donald Trump was out of office in early 2021, several Republicans, including Mitch McConnell, who I don't quote often, noted that Donald Trump could be charged with these crimes, and that was the basis for some of them saying that they were not going to convict him through the impeachment trial. So that happened, and that was a dramatic departure from the law in America, and one that comes on the eve now of the 250th anniversary of our nation's Declaration of Independence from having kings. And you had John Roberts playing a kingmaker role, in essence, to imbue Trump with these powers. But that's not all. As we've seen this year, we've seen a series of rulings, nearly 24, but not quite, where this Roberts Court has intervened to block well-grounded rulings by lower court judges based on detailed factual evidence, based on thorough discussion of the law, meaning the Constitution, statutes, precedents, regulations, contracts in some instances. Those rulings found that Donald Trump's unilateral actions, some of these extreme actions that he's taken or assertions of power, create irreparable harm for the plaintiffs. There were detailed findings of that irreparable harm, and findings that the plaintiffs had a substantial likelihood of success on the merits based on existing law. But the Roberts Court wasn't done immunizing Trump retrospectively and prospectively in the current administration through that ruling last year. It sought the Republican appointees to that court have sought to mow down lower court rulings to enable Trump to go farther than any president has ever pressed the law in numerous areas, including areas where the Constitution expressly provides that those powers belong to Congress, not to the president. They're Article 1 powers, not Article 2 powers, and expressly so. That includes things like impoundment, ripping money away. That isn't just a budget like on the back of your, checkbook or something. This is a budget. These are budgets passed by Congress by majority rule, signed into law by a president, and that money is supposed to be allocated to agencies, to cancer research, to the array of things. So the John Roberts Court has been enabling Trump, but to kind of draw the lens back a bit, this is not the first component of how John Roberts has helped unmoor our Constitution from its principles. In 2013, John Roberts took the pen to author the Shelby decision, the decision involving Eric Holder in Shelby County, where he struck down, in essence, he neutered key enforcement provisions of the Voting Rights Act in Section 4 and Section 5. Those were the pre-clearance provisions that required jurisdictions that had a history of racial discrimination, of anti Black voting, basically of trying to block Blacks from voting in America, that those jurisdictions would have to seek pre-clearance from the Justice Department before they could change the rules, because they had demonstrated amply that they would change the rules to make it harder for Black Americans to vote. So Roberts did that, even though Congress just a few years earlier had extended the Voting Rights Act for more than 2 decades, had reauthorized it based on detailed factual findings. But because Roberts is such an arrogant ideologue, so devoted to the pre-MAGA Reagan revolutionary ideals that he has been devoted to for so long, he swept away those congressional findings, which is actually not the job of the court. The court is supposed to defer to those detailed factual findings. And Congress expressly, as you all know, under the 14th and 15th Amendment, in the enabling clauses of those two amendments, Congress is empowered expressly to take whatever necessary legislative means to enable that voting rights be protected. That is an express provision in our Constitution that was adopted, as part of the amendments to our Constitution following the Civil War. But John Roberts disregarded them. What I want people to know beyond that in this moment, in the aftermath of the arguments, the oral arguments just yesterday before the Supreme Court, the reporting, talks about how these Republican appointees are somehow now going to embrace racial neutrality, they are formal neutrality, that we can't have race-specific remedies, despite the fact that this court and some of the people asking those questions, I'll say Brett Kavanaugh specifically, for example, just in the last few weeks, helped overturn a lower court ruling that had blocked this administration from engaging in racial profiling, in profiling people, seizing people through Kavanaugh stops, aptly now called Kavanaugh stops, based on their race, their ethnicity, their physical, appearance, the language they speak, or the jobs that they hold. So you have, on the one hand, an aggressive action by this Roberts Court to make it easier to engage in racial discrimination in a way that is indeed pernicious and damaging and rips people from their homes, from their families, from their jobs, and yet pretending on that dais of the Supreme Court that we suddenly somehow live in a racially neutral land and we cannot have the enforcement of Section 2 of the Voting Rights Act, which was specifically passed to protect from the dilution of Black voters and Black voting by white legislatures, which is exactly what happened in Louisiana, and has happened in Alabama, and has happened in Mississippi, Georgia, Florida. When you look at Louisiana, you all know that Louisiana has a population that is 1/3 African American. And yet that white legislature created a map that made for 5 white majority seats and 1 Black majority seat. And that 1 Black majority seat is the one that is being targeted in this litigation. Now, this isn't happening out of the blue. This Supreme Court takes cases completely discretionarily. Almost none of its cases are required as part of mandatory jurisdiction. It is choosing to take up this Louisiana case, and is choosing to do so now in this moment, this summer, as the President of the United States has been urging legislatures to redraw the maps, to rig the maps so that he can maintain control of Congress and a majority in Congress. But that's not all. And I guess, am I at 15 minutes? I'll end here and come back if you'll let me. But that's not all. This case that is before the court right now is on the very issue that John Roberts launched his legal career around. And in my book, I detail how in 1980, the U.S. Supreme Court, in a decision that was issued in part by William Rehnquist, took a hammer to Section 2 of the Voting Rights Act, tried to neuter out the Voting Rights Act provisions that allowed the effect of a change in voting or a map to be considered proof of a violation of the Voting Rights Act. That provision was key to that 1965 landmark legislation that was purchased with blood and sweat and tears and decades of effort to secure our civil rights and the promise of the Civil War and the post-Civil War amendments. But when Roberts went to work for the most regressive member on that Supreme Court at the time, Bill Rehnquist, across the street, Congress was busy trying to remedy that, trying to fix and overturn that Supreme Court decision. As I noted in my book, one of the things that his fellow clerks remarked upon was how aligned John Roberts was with Bill Rehnquist. Now, Bill Rehnquist wasn't just the most regressive justice at the time of the Supreme Court. He was someone who actively engaged in voter suppression in Bethune, a neighborhood in Phoenix, Arizona, that was a predominantly Black neighborhood, where he went with a camera without film just to intimidate voters in that community. That's who John Roberts clerked for. That's who he spent his time with. That's who he was, he stodged with. And then what happened is that Bill Rehnquist called Ken Starr, who was then the chief of staff, top advisor to the attorney general for Ronald Reagan, and asked him to hire his clerk, John Roberts. What happened next is that John Roberts was put in charge of the attack on Congress's effort to remedy the Supreme Court's decision in Bolden to unwork the Section 2 of the Voting Rights Act. Congress was trying to say that intent is not the only way to prove a violation. You can show it by effect, John Roberts went to war on an effects test. And that's also what is at stake now. So this is part of a long battle. This has been more than 50 years of John Roberts' hostility to voting rights, his embrace of a fake notion of pure, of equality where you cannot consider race to address racism, to address discrimination. And so if you have any doubt or somehow a hopeful belief that this court, this Roberts Court, is somehow not going to continue to decimate the Voting Rights Act, I'm sorry to tell you, you would be wrong. And that's why we have to come together to recognize this reality and build a movement to reform this court, including through term limits and other measures, because until we reform this court will continue to damage our republic, to erode our freedoms, to decimate hard-won rights, including civil rights in America. And we have a moral obligation to stand together, come together, not just at No Kings, but for as long as it takes to restore and expand our freedoms.
Amen. I want to hand it to Marge Baker, now our executive vice president, whose knowledge of the court and justices is unmatched to lead the next set of questions. But first, Lisa, the title of your book is Without Precedent. And it is a grim topic, but important to learn how to stop it. And I keep getting questions in the chat, and we're going to get into this. What can we do? What must we do to stop it? Let's focus first on this term, and then let's talk about what all of us can do as citizens. First, our executive vice president, the person who in and outside of DC, I could say is rightly most associated with our good, great work, is Marge Baker.
Hey, thanks a lot, Svante. And Lisa, it's so good to have you. So good to have you on. I was saying earlier, I noted a post that you did today that talked about Roberts not being an umpire, but him being a Trumpire, I think it was. And that's so true. I wanted to talk for just a minute with my colleague, Paul Gordon, who is one of the exceptional members of our team, about the role of dissenters on the court. I've seen descriptions of the three liberal justices on the court, Kagan, Sotomayor, and Ketanji Brown Jackson, who have somewhat different styles. It was said that Kagan looks at the shoddy reasoning of a majority, that Sotomayor looks at the complicity of the majority in doing harm, and that Ketanji Brown Jackson frequently places all of this within the larger systems of oppression. So those are important dissenters on the court. So Paul, speak for a minute about, in addition to the inspiration they provide us, what's the important role that dissenters on the court play?
Yeah, I'm happy to do that. Everyone, I'm Paul Gordon, Senior Legislative Counsel with People for the American Way. It's easy to fall into a trap of thinking that the dissents don't matter. It's true, the dissent is the side that lost the case. By definition, they didn't get their way. But the dissenting opinions are really important. They matter a lot. If they didn't matter, then the justices wouldn't spend so much time and energy into writing them. I think they would probably rather spend their time taking longer vacations. But they understand that as a Supreme
Paid for
Court justice,
apparently by whomever, these vacations. It doesn't matter.
yeah, exactly.
Yeah, you get an RV and you get an RV. Okay, so
the justices understand that with their dissent, that they have the power to shape legal and public opinion through those dissents, and that's really important. It's really important in the long run. It's also important in the short run. So just to sort of talk about some of the reasons why it matters. A dissent can give voice to a community that has been completely excluded from the majority decision. So like an example of that would be, there was a decision a couple years ago in the case called 303 Creative. This is where the majority gave the anti-LGBTQ people a constitutional right to discriminate, even when there are laws that prohibit exactly that type of discrimination. The dissent wrote about the impact of discrimination on real people. The dissent talked about the constant loss of dignity every time you're turned away from a place of business. They talked about the humiliation. They talked about the frustration, the embarrassment. That is a part of the story that the majority does not want to talk about. So they don't talk about it, but the dissent talks about it. The dissent is not going to let them hide it. That's critically important. And another thing that the dissent can do is they can really help shape public discourse. And my favorite example is in the case Lisa mentioned a few minutes ago, Shelby County versus Holder, where the majority gutted the pre-clearance provisions of the Voting Rights Act. They said, well, there's been so much progress since the 1960s, we don't need it anymore. And Justice Ginsburg wrote a terrific dissent to that. And she said, throwing out pre-clearance because it's worked is like standing in a thunderstorm with an umbrella and saying, oh, I don't need my umbrella, I'm not getting wet. It was a wonderful simile, and everybody was talking about it because it helped people understand the absolute absurdity and illegitimacy of that majority opinion. It showed that the emperor had no clothes. Her simile really helped shape the public's understanding of just what it was that the majority did and how illegitimate it was. The dissents are also like they're planting the seeds for the future, for progress in the future. I'll just give one example. There's a case from the 1920s where Justice Brandeis was in dissent. And it was a case involving people's privacy. And he talked about privacy in an amazing way. He said, the Constitution gives us the right to be left alone. And that is the most comprehensive rights that is most valued by people. That position later became part of the majority and became a central part in how courts and the greater society talks about the right to privacy in the Constitution. It is cited regularly now. So it was like a seed that he planted with great frustration, I'm sure, when he wrote that dissent in the 20s, but it became very useful in the future, and we use it now. And then just very briefly, some of the dissents in the shadow docket cases that we talked about, they frame the issues beyond the legalese in those specific cases in ways that grab headlines, and they make it clear to the American people just how big the stakes are. So I'll just give a couple of examples. Justice Sotomayor wrote a dissent where she said, no right is safe in the new legal regime this court creates. I mean, that's direct and it's powerful. Justice Jackson said that the majority was creating a zone of lawlessness. She said that people who would otherwise be entitled to the law's protections become subject to the executive's whims instead. So by writing like this clearly, this directly, they're basically banging on the door and saying, pay attention, this matters. And that plays an enormous role in making sure that these decisions get the press that they deserve so that people understand what is happening. So dissents are enormously important.
Yeah, thank you, Paul. Because okay, so what if it's not clear by now, on this webinar, we are trying to recruit all of you. I know you're thinking, I'm a member, I paid my dues last year. First of all, make sure you did pay your dues. No, second, you're like, I'm already a member, recruit us for what? the way to stop this, the way to build a better judiciary and therefore a better country, is to inform more people about it. And you, all of you, the very fact that you're here shows that you care. We are attempting to arm you with as much information as possible so that you can all become influencers, either through your social media accounts, through your email contacts, through people you know, strangers on the street, stop somebody in the coffee shop. And we want to make sure that you have as much information. And at the end, we're going to talk in even harder terms about the work that we intend to do and how you could join us in that work to stop this. So I'm going to ask you another question, Paul, but I wanted to say that first, to say that we're not just admiring the problem here. Even though I'm about to ask you to admire the problem for another 5 minutes, which is, what additional damages might we expect from this coming term, including on voting rights, given yesterday's oral arguments? And as folks on the webinar, you're putting your questions in the chat, be thinking, how can I incorporate this information from Paul, one of our experts, and from Lisa, from Elliot, in the conversations I'm going to have with my neighbors when I'm convincing them to take action, particularly convincing them to go vote with the courts in mind?
Yeah, the things that they're gonna do this term, it's some pretty scary stuff. Yesterday was the oral arguments in the Louisiana voting rights case that Lisa went into detail on. The idea that taking race into consideration when crafting a remedy to racial discrimination in voting is just so Orwellian. And so thank you, Lisa, for talking about that so clearly. I would love to say that I heard things in the oral arguments that made me think, oh, the conservative justices, they're not going to do anything bad. Yeah, right. It is possible that another key element of the Voting Rights Act is going to go out the window. That could have the effect of wiping out a lot of majority Black districts, House districts in the South, especially. It could affect the balance of power in the House of Representatives, which I'm sure isn't at all a consideration for these far-right justices. They would never think about that. So the oral arguments in that were yesterday. There are a couple of important cases on LGBT equality. There are two cases that are addressing the right-wing efforts to keep trans women and girls out of women's sports. There's one from Idaho. It's called and I'm going to mispronounce this person's name. It's Little versus Hecox or Hickox. I am not sure how to pronounce it. But Idaho's got this blanket ban on trans women and girls in women and girls sports. Idaho is in the Ninth Circuit. The Ninth Circuit said this law can't be enforced. It's because of it was a constitutional decision. They said it violates the Equal Protection Clause. It discriminates on the basis of sex, and it discriminates on the basis of gender identity. It targets transgender people. It is unconstitutional. The second case in the same general topic is from West Virginia. They've got a similar ban, but this is a much narrower case. It's about a 13-year-old trans girl who took puberty blocking medication, but the school still banned her from girls' sports. This case went to the Fourth Circuit. The Fourth Circuit said what the school is doing is illegal. They decided on the basis of Title IX, a statute passed by Congress that prohibits sex discrimination in education. But they said it as applied to this one particular individual, this one 13-year-old, given her particular circumstances. The state still appealed it to the Supreme Court. So we will learn a lot based on how the court answers these questions. This is not a majority that is friendly to trans people, as we have seen. So, we will see what they do. Another LGBT-related case is one called Child versus Salazar. Someone is challenging a Colorado law that protects LGBT kids. It says that if you're a licensed therapist and you have minor clients, you can't try and change their gender identity or their sexual orientation, protecting them from conversion therapy. So this is being challenged by a therapist who says that the law violates her right to free speech because therapy happens through talking. And she has religious beliefs about sexual orientation and gender identity that I would guess are not exactly pro LGBTQ. She is being represented by the far right Alliance Defending Freedom. So this is a law that sets medical standards of care to protect kids from treatment that has been shown to be harmful. So one question is going to be is the fact that the treatment occurs through talking, does that mean it's going to be triggering free speech concerns? There's also some talk about whether this law would even apply to this therapist. They may dismiss the case on that account. We're not sure. We will see. A couple of cases on Trump's efforts to be an autocrat. We'll have a lot of those in the shadow document, but two that are scheduled for oral arguments. One of them is called Trump versus Slaughter. And this is about Congress sets up some agencies to have a level of independence from political pressure. They have requirements that they're led by boards. Some members, they can't all be with the same political party. And the president can't fire any of the heads without just cause. And the Supreme Court upheld this sort of structure back in the 1930s, a case called Humphrey's Executor, an important case from the New Deal era. Trump doesn't care about that. He wants to do what he wants to do. And he's fired Democratic members of the National Labor Relations Board illegally. He fired Democratic members of the Consumer Protection Safety Commission. And in this case, involves firing Democratic members of the Federal Trade Commission. So the Commissioner Slaughter went to court, and it said, the lower court said, well, while this is it's so blatantly illegal that she can stay in her office while the litigation proceeds. And Trump went to the Supreme Court. He's looking for relief from this horrible decision. The administration wants the court to overrule Humphrey's executor and basically let Trump fire any member of the executive branch anytime he wants, no matter what the statute says, just because he wants to. This would give him immense power that Congress has carefully set up these agencies to make sure the president doesn't have. A related case is one called Trump versus Cook. That involves firing a Democratic governor of the Federal Reserve Board. There's also a law that says you can't do that without cause. Trump, in this case, said he does have cause. There's some rather spurious accusations against the governor of the board about things she supposedly did before Biden named her to the board. These accusations have been totally debunked. She went to court and she said, this firing me is illegal. And Trump is saying that once I've said that I have a cause to fire you, court can't even look into it. The court can't look into whether it's accurate what I'm saying. It can't look into the issue of, one of the things the lower court said is, if you're going to fire someone for cause, then that cause has to be related to their job, something they did on the job. And Trump is citing something that supposedly happened beforehand. He said, none of that matters. As soon as I give a cause, that's it. Courts have no business getting into my business. So a lower court said that she could stay in office while it's being litigated. But this is Trump looking for the power of a dictatorship and to be able to exercise much more control over the Federal Reserve, which would be a very dangerous thing. There's some other cases. Yeah,
Paul, excuse me just 1 second. It looks like Lisa might want to get in just for a second.
Oh, yeah.
Yeah, go ahead, Lisa.
Yeah, there's been a lot of talk in the chat about whether dissents matter, and I would just say, I think they matter if we make them matter. Those are very important statements by the justices in dissent to these emergency docket rulings, and they've been describing how very dangerous these rulings are for all of us. And we have seen in other countries where authoritarianism has been on the rise, how important it has been when judicial figures are willing to speak plainly and publicly about the way that people's rights are at risk. And so my wish would be for some of the key statements in those dissents to be shared as widely as possible, to become parts of signs and more outreach, because we are going to need people to understand that this is not just another Supreme Court term. This is a Supreme Court term that comes on the heels of the most radical ruling in our lifetime. And I would say the most radical ruling in some ways in constitutional history to give a president the power to behave in ways that transgress the law and put all of our rights at risk. And so this other question of what can be done. Well, nothing can be done in the instant moment to change this Congress, to get it to pass reforms or to get this president to sign those reforms in law. But that's why we need to have strategic patience to use every one of the illegitimate rulings coming down from this court where it is violating long-standing precedents in order to aid the political party of the party that appointed them to this court, where they were chosen and handpicked to become part of this captured court, where those decisions become the fuel for us talking to our neighbors about why we have to reform the court, why we need the John Lewis, Act to restore the voting rights, and on and on and on. We cannot let the fact that in this moment this Congress is not a friend to the American people's rights limit us from aiming for beyond this moment to build this movement together.
Yeah, that's exactly right. And we want to get in a minute to all of the ways in which folks can implement that. I just wanted to point out, at least in your book, you start with what got John Roberts to where he is, which is years and years and years of persistence. It took decades for him to get the court to the place where it is now. We need that same persistence. We need that same persistence. And what Paul is framing through the talk about dissents is the language and the explication of why these things matter. I want to just turn to Elliot for just a minute, because the other place we get that inspiration is from the lower courts. Many of the lower court judges on circuit courts and district courts are making the case that the Supreme Court, sadly, is frequently mostly rejecting, but they're making the case in the strongest terms possible for why what the Trump administration wants to do, why this assault on our democracy and assault on our rights is so critical. So, Elliot, if we could turn just to you for just a brief discussion of why do these lower courts matter? This community was responsible for President Biden being able to put 235 judges and one justice on the Supreme Court because of the energy, because of the organizing. So tell us, Elliot, why it makes a differwant. Oh, I'm sorry.
And and because we're running short on time, both in this webinar and in our democracy, we'll want to move after this question directly to what could be done next.
Great.
Thank you very much, Marge, and thank you to everybody for being here on this webinar. The reason lower courts are so important is a matter of simple math. 9 Supreme Court justices, 850 plus lower court judges, including hundreds by now nominated and appointed by Trump, which is one reason you can do something, help us oppose more of those nominations. And while the Supreme Court gets the final authority, it is true that lower courts have played a critical role. I wasn't going to give 2. Let me just give one very recent example of a lower court judge, Judge Immergut, who was actually appointed by President Trump. But when the issue came up about Trump taking over the National Guard and sending them into Portland, she was the one who issued a temporary restraining order stopping that from happening. Now, that case made its way up to the Court of Appeals, and in an initial hearing, which had 2 Trump judges on it, we saw what Trump Court of Appeals judges do. They made pretty clear they'd go the other way on the issue. But that decision hasn't come down yet. Judge Immergut has extended her ban for another 2 weeks. That is just one of countless examples of lower courts playing a critical role in holding Trump accountable and in stopping some of what we've seen all along. Another example I was going to give had to do with a Clinton judge who essentially stopped Trump from firing all of the people that had been laid off as a result of layoffs from the government freeze, they technically still have their jobs to go back to. Not if Trump has something to do with it, but fortunately, this judge, at least temporarily, stopped anything like that from happening. So the lower courts play a critical role, and we play a critical role in scrutinizing what they're doing. Take a look at our confirmed judges, confirmed fears series. You can see some of the awful decisions that Trump lower court judges have done. But even some of the Trump lower court judges are seeking to hold Trump and his colleagues accountable. And that's why lower court judges are so important.
Yeah. Thank you, Elliot. I mean, this is we could go for hours and hours, and we do here at the offices of People For, because not only do we investigate this, but we report on it. We try and get this to the broadest audience possible, because we believe that the courts matter a lot, and we believe that when Americans understand what's happening with the Supreme Court in particular, they do not like it. But there's been so much deference, even it's in the name, the Supreme Court. The fact that there's no pictures or videos inside the court, it is harder to get people's attention, which is what we've asked all of you here today to help us with. I mean, yeah, we run ads in people's districts. We send out mailers. We're being increasingly aggressive online when it comes to court nominations. And of course, we're extremely busy on the Hill and in the White House arguing for and against good justices. But I want to ask Marge Baker in closing, and also our a special guest who's joined us, a longtime board member and somebody who's very, very used to turning her voice into power, real power, to not saying, I think Marge said before, you know, that Justice Roberts had been patient. He had been deliberate, you know, and I think there's a patience in, as I said before, panicking constructively. I wouldn't say we should be patient as in just sit and wait for something good to happen. It is time to panic, but it's not the time to panic and say there's nothing to be done. There's so much to be done. And so for that, and to close this out, I'd like to ask Marge first, what are the most immediate next steps? What can the people on this webinar do? What are people for the American way going to do? And this Supreme Court turn and beyond to stop this injustice. And to close this out, I'd like to ask, again, somebody with a lot of experience about using a voice to make real powerful change in the real world. The incredibly intelligent and articulate award-winning actress and activist, Alyssa Milano, to close this out.
So let me sum up some really, really important things I think folks can do. One is help us carry the message that courts matter in people's lives and give examples. Courts matter to economic justice. Courts matter to workers. Courts matter to consumers. Courts matters to clean air and clean water. If those of you who are going to the No Kings rallies on Saturday, carry a sign that says no kings, fair courts means no kings. Fair courts protect our democracy. Fair courts protect rights. Use whatever platform you have to get the word out. Help us tell the story. We've got lots of materials. We've put them in the chat. We will continue sending them to you on what the Supreme Court's doing, what lower courts are doing, good and bad. Use that information. Use Lisa's book. Use all the information you can to, in your own words, tell the story and use whatever platform you have. And Saturday is a good day for a platform. Secondly, vote. Make sure you and everyone you know understand that a vote for the president, a vote for the Senate is a vote for the court. So vote for fair courts. It will take time. I'm not saying this election is going to turn things around, but it will take time. Persist. Just stay with it. In terms of some of the battles some of the fights where you can engage in order to carry the message forward. Again, we're not necessarily going to win all these fights, but you use the fights to carry a message. I worked for Paul Wellstone for a couple of years, and I remember there was an issue around the steelworkers having concern about their pension rights. And he said to the steelworkers, give me a bill. I need a bill. Give me a bill so I can organize around it. So the point is, here's what you can organize around. You can organize around lower court nominations that we are seeing right now from Trump, putting more people on the bench, like the folks he has already put on the bench that are doing horrific things to people's rights. Get ready for what could be, drum roll, a likely Supreme Court vacancy next year. We could see that. And so we have to be ready now. We have information on folks who are likely prospects. We will share that information. We need to be talking about that now. Get some of the measures you can push: court reform, term limits, court expansion, a binding ethics code to the Supreme Court. Again, we're not going to get that tomorrow, but the point is having it out there as a way to say we have to deal with the current environment of this utterly corrupt court. And there are ways to do it. There are legislative fixes to that we can do. And then the other thing is there's legislation to combat the bad court opinions. There's the No Kings Act, which addresses the immunity decision. There's something called the Protect Our Democracy Act that curbs the pardon power abuses and enforces the emoluments provisions, and on and on. There's the Preventing Political Prosecutions Act, which is not yet out, but Senator Blumenthal has some ideas for how to deal with and curb political prosecutions. There's democracy legislation, the Freedom to Vote Act, the John Lewis Voting Rights Act. We can codify abortion rights that the court has taken away. We can enact gun safety legislation, and we can do a constitutional amendment to overturn Citizens United. There are so many ways, again, and we're not going to get this done tomorrow, but we're going to advocate for it and use the advocacy as a way to educate about how important this is. And I'll come back to one of the most important things is vote. When you vote for the Senate, when you vote for the president, you are voting for whether or not you have a fair court. So those are just some of the things that we can do. And hold on to the hope. Hold on to the hope. I got up this morning, this is a hard time, but I got up in this morning to see pictures of hundreds of Pentagon journalists leaving because they wouldn't go along with Pete Hegseth's effort to censor what they can report on. People in their own way, are standing up and fighting. And so that's what we need to do. We find a way to get our voice into the mix. And so we welcome you. We treasure the members. We have resources available, and please contact us if there's anything that you need that you don't see.
Including, there's so many good questions in the chat and so many great questions were sent in. I would love to be able to, we will do our best to send out to everybody who participated in this briefing answers to those questions, because there's so many smart and pointed ones too. And again, Alyssa, if would love to have you close us, because I mean, you might, some folks from Who's the Boss, some folks from Charmed, most of us know most of her career, but I hope you also know that when she very early, like one of the first, when she took Me Too and amplified it at great risk to her person and her career, that was not a surprise to those who've known her activism. And she shares her voice. She reaches millions and millions and millions of people every day.
Okay.
And unlike a lot of folks who I won't.
Thank you.
Well, okay.
Thank
But
you.
unlike a lot of folks who duck that.
Today, I have
it.
so much to say, and I love you so much. And thank you to Marge and Savante and Lisa and Paul and Elliot. Like, this has been so great. And I didn't plan on, I said to Savante, sure, I'll say something. I'm a mess, but you know what? So is our democracy. So it kind of fits. But I have so much to say. So excuse me if I'm scattered and all over the place. But first, let's talk about voting for 1 second, because I'm in California and we have Prop 50 that we are currently like in the process of voting on, and my husband's ballot came and mine didn't. And so I was like, you know what, I'm just gonna check my registration just to see, and I was purged from the voting rolls. So I want to encourage everyone to check their voting registration before it is too late. We made the cutoff. I made the cutoff in like 4 days, and it would have been too late for this election. So that is scary, and I'm sure I am not the only one. So there's that, which I'm super concerned about. I think I think the point that Marge made is very important, which is this idea of planting seeds within your community about all of the issues that you care about. And I often think about, being an activist, and I'm sure there's many activists on this call, but it's like I would say 98% heartache. And every once in a while you get a win. And that's really hard. And it's hard to keep going. But I think about people like Alice Paul, who wrote the Equal Rights Amendment that is still not in the Constitution, but we don't want to make a lot of ruckus because I'm afraid what Trump will do, but we are closer than ever before on guaranteeing women equal rights and strict scrutiny in the Constitution. But when Alice Paul wrote this over 100 years ago, obviously she never saw this point. And so I've learned to try to think of activism and the work that I put in there as the seed that's planted with hopes that my grandchildren will be able to sit under the tree from the seed that I planted. And I think that's how we all have to look at this time right now. It's hard. And listen, I just want to say what we're seeing in the court today is exactly why so many activists, so many of us showed up and fought our hearts out and cried in Congress members' offices during the Kavanaugh hearings. We totally saw this coming. I remember going into Murkowski's office in the Senate and just being like, I can't, like, she felt to me like the only reachable Republican. I don't even think she's reachable anymore, but we knew this was coming. And I feel like during that time, we got real used to fighting behind our screens. And it worked for a little bit, but I don't think it works as well now. I don't think just posting on our social media is enough anymore. I especially don't think it's necessarily safe anymore. I think, I mean, I'm sure that my social media account is flagged for whatever they find suspicious anti-regime rhetoric, right? Even though it's truth and fact and sometimes even science. So I want to encourage people to put their boots on the ground and do some old school organizing. Get into someone's garage or a basement or a church, hand out flyers, make flyers, hand them out when you're, in a parking lot, doing your grocery shopping. Really, I want you to think about bringing this back to face organizing. I think it's vital, and I think it's the only way that we're going to win. Plus, they've surpassed us in digital organizing. They're really good at it. We're really good at? We're really good at connection. We're really good at feeding love and hope and faith and acceptance. And we need to do that in front of people. So I know you're tired. I am so tired too. But this to me is a moment to get off of social media and get back into the streets, get back into our communities, into action. And I really feel like this is where our democracy is going to be defended. It's not going to be in hashtags, but it's going to be in real life. And thank you for supporting People for the American Way. It is just the most, I think, and believe me, I'm on a lot of these Zooms, and if I hear one more talking point, I'm going to explode. These are people that are doing the real work every day. So your support means everything to us. And we will keep working. And thank you for being here and for fighting and for not giving up. And I'm just going to end on this. my best friend did this really sweet thing for me for Christmas last year, and she made me this little like box, and because all of these little cards have little sayings on them. And so this morning, every morning I come in and I pick one of these cards and I put it up, and then I look at that all day, and that's sort of my North Star for the day. But today's I thought was appropriate for this, so I'll just read it out. Your mind will always believe everything you tell it. So feed it faith, feed it truth, and feed it with love. And I feel like that's what we did today. So thank you so much.
Oh my gosh. Thank you. That was with no prep. Amazing.
No prep. No prep.
Amazing.
I'm better off the cuff.
Incredible. We should do that more often. Thank you, Alyssa. So appreciate it. Lisa, thank you so much for being here. Your book, Without Precedent, is available now. Marge, Paul, Elliot, I'll see you 6 or 7 times tomorrow, at least. Zach, thanks for organizing. Thanks for all of you for being here. Really appreciate it.